Well, an aggressive move by the attorneys for a Camas woman accused of poisoning her husband and writing a children's book about processing grief. Her defense team now asking the judge to officially sanction the prosecution.
They also filed a motion fighting back on the state's request to keep Kouri Richins away from her mother. 2 News' Paul Nelson has the latest.
Kouri Richins' defense team argues that one of the reasons the prosecution gave to keep Richins apart from her mother turned out to be wrong. But one legal analyst says even if that's accurate, that doesn't mean the prosecution will not get what it's looking for. The walk the dog letter, which reportedly was found in Kouri Richins' jail cell, might be getting the most attention in the national spotlight, but it is not the only letter. The state claims Richins showed her mother another letter during a visit, then either flushed it or destroyed it. In this week's opposition motion, her defense team claims that second letter was found after the state made their request. They believe the no-contact motion should be refused. But former Salt Lake County prosecutor Nathan Evershed says new evidence wouldn't necessarily mean the no-contact motion would be tossed out.
It would mean that the motion would have to be supplemented.
Richins' attorney also filed a motion requesting another hearing so they could ask the judge to sanction the prosecution over claims of jury tampering and how they released the walk the dog letter to the public. Evershed understands why attorneys would have to fight tooth and nail over that letter.
I view this letter to be a bit of a bombshell. This is something that is major.
Evershed says few things are as persuasive to a jury as a defendant either admitting to a crime or appearing to cover their tracks while in jail.
When I had cases as a prosecutor, the defendant's own statements, particularly from the jail cell, like in a phone call that was recorded or something, it has such evidentiary weight in terms of the jury trial.
He believes the big question will be whether or not the walk the dog letter should have been sensitive information protected by attorney-client privilege. Evershed believes both sides have a good argument.
All of this is going to be played out in court as to what the judge determines this all to be, but there's a reason why there's this much filing on that letter. It's because everybody knows that letter is a major deal.
Defense attorneys tell us it is perfectly legal for an accused person to tell another person what to testify to as long as it's the truth. And that's why Richins' attorneys say that the state should have never accused her of witness tampering. Paul Nelson, KUTV 2 News.